All right, everyone. I am Pastor Dave. My channel is Young's, bringing you the voice of truth for this July the 10th, 2013. If you think that the NSA is acting alone and they are the only ones collecting massive amounts of your personal information, you better think again. Here's the headline. I'll put the link below. Breaking story coming out today, July the 10th. Federal judge authorizes Chevron sweeping subpoena of activists' internet data. It's not just the NSA that's collecting massive amounts of personal data with judicial approval. In a ruling publicized by Earth Rights International, a federal judge in New York approved a subpoena by Chevron to obtain any documents Microsoft has related to the identity of 30 anonymous individuals allegedly of interest in the litigation, including every IP address over a period of 9 years. The case involves an $18.2 billion judgment against Chevron in an Ecuador court for massive environmental contamination from oil drilling. The Ecuadorian court found that Chevron had dumped toxic waste into Amazon waterways used by indigenous groups for drinking water and caused massive harm to the rainforest. Chevron responded by filing a lawsuit in U.S. court alleging that the plaintiffs engaged in a conspiracy to defraud the company. As part of this lawsuit, Chevron has subpoenaed Google, Microsoft, and Yahoo to request all information related to the email addresses of more than 100 advocates, journalists, lawyers, and others. These individuals are not parties to the suit, but Chevron alleges that they are involved directly or indirectly in the litigation, and they have been outspoken critics of Chevron's conduct. U.S. District Judge Lewis A. Kaplan explains the scope of what Chevron was seeking from Microsoft. To summarize, if Microsoft still has and were to produce the requested information, Chevron would learn the IP addresses associated with every login for every account over a 9-year period. Chevron could identify the countries, states, and even cities where the users logged into accounts, and perhaps in some instances could determine the actual building address or your home address. Chevron would not learn who logged into the accounts. That is to say that Chevron would know who created or purported to create the email accounts, but would not know if there was a single user or multiple users for each account. Nevertheless, the subpoenaed information might allow Chevron to infer the movements of the users over the relevant period at a high level of generality, and might permit Chevron to make inferences about some of the users' professional and personal relationships. Last month, the court granted the first of these subpoenas in full, holding that the anonymous individuals were not entitled to First Amendment protection because they may not be U.S. citizens. They may or they may not be, as human rights lawyer Marissa Vashling explains. The account holders in this case were proceeding anonymously, which the First Amendment permits. Because of this, Judge Kaplan was provided with no information about the account holder's residency or place of birth. It is somewhat amazing, then, that Judge Kaplan assumed that the account holders were not U.S. citizens. As far as I know, a judge has never before made this assumption when presented with a First Amendment claim. We have to ask then, on what basis did Judge Kaplan reach out and make this assumption, given similar suggestions that NSA data collection is limited, at least in some ways, to non-U.S. citizens? This decision, much more public and available than the secret but reportedly expansive rulings of the Foreign Intelligence Surveillance Court should give serious pause to those who think that limiting data collection to non-U.S. citizens protect the rest of us. It is worth noting that this case involves only the First Amendment and not the Fourth, because parties in civil suits have a whole lot of leeway to access data via administrative subpoenas, which are typically not considered searches and or seizures under the Fourth Amendment. Nonetheless, their speech, associations, and political activities remain protected under the First. I ask that you share this video, like this video, subscribe to my channel. And once again, here we go. Here's the headline. Federal judge authorizes Chevrons sweeping subpoena of activist internet data. Leave me comments. What do you think?